For those of you that have been with us before, as always, Southern States Management Group hosts educational forums, in-person events, webinars, newsletters on a regular basis. The leadership team has invested a lot of time and resources into providing education to board members that work with us and that are not in our portfolio as well. We as an organization believe that the more educated a board member is, the better their communities will run, and in turn, all of our communities will run better. So we appreciate your volunteering as a board member, and we know it's a thankless job, so thank you. And we appreciate you being here tonight. With that, I also want to say that by being a part of tonight's webinar, it will be videoed. So this is a disclaimer letting you know that we are videotaping this for our social media and library resource needs. So if you are not comfortable with that, this would be the time to log off. And then with that, I will turn it over to Barbara to do the introductions of our panel.
Sure. Okay, thank you, Diane, and thank you everyone for attending tonight. My name is Barbara Reid. I'm an attorney with the law firm of Wright & Casey in New Smyrna Beach. I practice in the area of HOA and condominium law. That's my story. I'm here, fortunately, with my colleague, Erin, tonight.
Hi, thank you. Thanks, Barbara. My name is Erin Wollett. I am an attorney at Wright & Casey. And like Barbara, I practice primarily in the field of association law for HOAs and condos. Great to see everybody. Thank you for joining this evening. It's obviously a very important topic. And so we hope to impart some information to you this evening.
Okay, I guess I'm next. I'm Charles Adams. I'm a structural engineer in New Smyrna Beach. We work all over the state. One of our specialties is repair of damaged concrete buildings. We do brand new construction, we do remodels, but for this little get together, I think the most interesting thing is that we are doing concrete repairs all over the state. And I think it's very important that as many people as possible get educated as to what can be done to prevent the kind of situation that happened in South Florida. And that's why I'm here.
This is Mike Mort. I'm with Insurance Office of America. I'm an insurance broker, 30 years in the business and 15 years specializing in the Condo Association program business. So I'm saddened. It's a tragedy what happened at Surfside, but there's a few takeaways and some information. I look forward to answering any questions anybody has on insurance as it relates to that matter and other matters going forward. Thank you.
Okay, Erin, did we get you in there too? And then Fred, Annon, I saw you jump in here. Did you want to say anything? You just have to unmute.
No, just good evening, and I'm glad that everybody took the opportunity to join us. I think it's a pretty timely and important topic, so I'm ready to move forward. Thank you all for being here. Thank you all for presenting.
Okay, great. Thank you. Okay, so the first question that we had come in, Chuck, this is for you. How often should a condo association have an engineering report?
If there's no obvious issues at the time, I think that you should have a structural engineer do a damage survey at least every 5 years. That's about as long as waterproofing lasts and paint lasts. And most condos need to renew those paint jobs and waterproofing every 5 years. So that's a perfect time to do a damage assessment to see what repairs need to be done. Now, I think it's the responsibility of the condo associations or every owner of a condo, if they see anything that looks bad, if they see rust spots, if they see cracks, if there's little chunks of concrete falling off the building, they should take the initiative and get to the board and demand that they get an engineer out there to make an assessment. This concrete damage is analogous to cancer. If you get a cancer on your arm, you don't put off getting it fixed. You get it fixed right away, because if you don't, it gets worse. And corrosion in buildings is the same thing. The Surfside job was a good example of taking too long to get the repairs that needed to be done.
I don't mean to speak out of turn, but maybe just real quick to supplement what was just said, that, you know, start by saying that condo associations, there is no statutory requirement, right, for what's called a reserve study. So I think maybe we should just start with just some basic things, because I think in my sort of research as to what happened in Surfside, I think the actual tower is called Champlain. I might be saying that incorrectly, but I believe it's called Champlain, right? One of the issues that happened here, this was not a scenario of a board that was caught flat-footed, right? They didn't have information. This was a total shock, right? I think even just a cursory review of some of the information that's out in the public domain about what's happened supports the fact that this was a well-informed board going back many years. This is a board that had in their possession multiple engineer reports going back many years that in those reports identified the issues in the building and over the years the further deterioration, right? What happened in this particular issue, or I'm sorry, this particular association, was that they had all this information, but as we all know, what that would result in is a very significant special assessment. And some of the reports that I'm seeing were in the 6 figures for some of the penthouse units and some of the larger units. They were looking at 6-figure special assessments. So obviously this was not popular. So what happens here is that the board receives certified engineer reports in, like, going back to 2018, that this is a problem. And for 4 years, there's massive infighting, right? The board starts to get traction. They may get close to voting on something, and then the owners, of course, you know, it's not super popular. And so what happens here is that a lot of time goes by, and of course things deteriorate, and then we have this tragedy. So at the outset, just keeping that in mind, that they had all this information. Florida statutes don't require a reserve study per se, but every board is required annually to have a budget that includes reserves, and that those reserves are supposed to be fully funded. So how can a board create an accurate budget with reserves if they are not using in some form a reserve study? So because most board members, many of the people that are joining us this evening, right, are not engineers, are not building specialists. So I find it hard to believe that a board could, in good faith, pass a budget with fully funded reserves if they're not basing those numbers on a reserve study. So one of the things that I think might come out of the Surfside tragedy is perhaps that the legislature will in fact change the statutes and require reserve studies, but currently that's not required.
I would just suggest that the reserve study is one thing. I think we're talking about a structural safety kind of a study that could be a separate issue that they do more frequently. And based on that, budgets could be established to do routine maintenance that can include small concrete repairs instead of waiting so long that it's becomes a 6-figure assessment.
Yes, absolutely. Absolutely. And to your point, one of the problems at Surfside was, in fact, that, and the board members, a month before the building collapsed, right, they had a board meeting where they said, we have allowed this to go on too long. We should have started saving 5 years ago. I mean, these were issues that started small, could have been addressed, certainly if they were getting more regular engineering reports, to your point, absolutely.
Yeah, and I think also that engineers, we get caught between trying to work for our client who may be the condo association, but when they don't act on things that we see as being serious, it probably is our responsibility to go to the building department and rat out our own client. And you know, I haven't had to do that, but I think engineers who are in this repair business have to be more aggressive with the associations and say, look, I know you can't afford this, but you can't afford not to do it. And the key is, again, not to wait too long. If they would do this regularly, it can be within the routine maintenance budget. It's the routine repairs just aren't that costly. It's when you go 20 years and don't do anything, then it becomes almost impossible.
Mm-hmm.
Yes. I guess to tack onto that, maybe is as we all know, Florida is one of the few states, right? So you're supposed to, as a board, pass your annual budget that's supposed to be fully funded. Your reserves, right, are fully funded. That's the term. But Florida is one of those few states that actually allows the membership by a vote to override that, to either underfund or completely waive the funding of those reserves. And to some degree, the Surfside tragedy, that's what happened for many years, right? They knew that they were supposed to do this work, that it was needed. They had engineer reports that certainly backed that up. But if every year the board brings a budget that's fully funded and the membership says, no, we don't want to pay that, we're gonna vote to either reduce or waive that funding. You know, in some respects, that statutory ability of the membership to reduce or waive of those reserves may have contributed to what happened. So that's another thing that might come out of the Surfside tragedy, is that the legislature may in fact take that out, and maybe it will no longer be an option, frankly, to vote to reduce or waive funding. And there's pros and cons to that, obviously. Barbara, I see you shaking your head. You know.
No, I'm just aware that there is a task force of condo lawyers that are on this, and they're going to present some suggestions to the legislature. And those, exactly what Erin is talking about, are some of the suggestions they're planning to make. Not allowing unit owners to waive reserves, requiring reserve studies, specifically reserve studies by an engineer every so often.
So I'm going to try to loop Mike in here on the insurance side, because interestingly, right now under Florida statutes, right, I just talked about how reserve studies are not required. I just talked about how by statutes, the owners can waive or reduce the funding of reserves. But the one thing that Florida statutes do require is, I think it's an insurance appraisal every 36 months. So Mike, maybe that's a good way for you to jump in and tell us how doing that insurance appraisal every 36 months, you know, can assist board members who are with us tonight with you know, complying with their fiduciary duties, and make sure that they are using that appraisal in the correct way.
Yeah, very good. So I think for the most part, 98% of the people that we touch and work with in the greater Volusia County, condos, high rises, all types of associations, condo related, they're accustomed to that 3-year update on the insurance appraisal. And the appraisal is, for those that are listening and may not know, the appraisal is really a replacement cost valuation. It's a independent third party that has the tools and the systems to figure out how much it would cost to replace your building if it was completely destroyed by flood or wind. So I think boards are accustomed to requesting or having to comply with that statute requirement. So I've never understood why this reserve study has not been a requirement. I mean, I've marveled at it and go, wow, so this might be something that comes from it. And it'll be a lot of the same companies that do the appraisals, also do the reserve studies. They're familiar with the buildings. And I guess my takeaway is on reserve studies, when I hear about them, there's this big challenge sometimes between what the board thinks it should cost and what some of the metrics or the software shows from these reserve studies. It's almost like what the reserve company comes up with is too great a number for the board to get their head around and really like, wow, we are not going to be able to raise our maintenance fees to comply with, you know, what they're saying. So they juggernaut, they go back and forth, and then they do this reduced number that really, I don't know that it really does too much, but that's what I have to say about insurance appraisals. They're accustomed to it. The reserve study would be a easy foray to comply with if it comes down to that, which I think it should.
Wouldn't it make sense for the insurance company also since you're going to do this reserve or reevaluation of the insurance every 3 years, to have a structural engineer spend a couple hours just doing a quick walk around the building and let you know if it's going to be safe or not for the next 3 years?
Yeah, so what we just started to see as of 10 days ago were underwriting questions that surrounded or were asking kind of pointedly about engineering reports. So there's going to be emphasis in this area as it relates to underwriting that will go from me, the broker, to the manager, and then to you as the engineer. And there's going to be another level of underwriting that's going to be specific to engineering and reports. That's for sure. I already see it on directors and officers insurance. So we haven't even gotten into the property insurance yet. That could be another level. So
yeah.
Well, I'm glad that you brought up the D&O, Mike. We have a question from a board member that states, and I don't know if this is you or one of the attorneys, but even though our COA has D&O insurance for our board members, could the members be sued personally?
This might be more of a legal question, but you know, you're coming in and you can be, I'll say it this way. A typical directors and officers policy is going to defend the current, former, and future board members. So for instance, Champlain Towers, if there was a board that was previous to the current, then their current policy would also defend the previous boards that may have been, we'll call them negligent, you know, perhaps in not doing their duty. So, but going to membership, no, I don't see that. I do see the policy defending also spouses. I don't know why that's brought in, but I see that very often. So past, future, and previous board members covered, their spouses as well, but the membership's never brought into it as far as I can tell, but I'm always learning. So, and I'll let you know if that ever changes.
Barbara, you wanna hop on that, or you want me to?
Yeah, no, I'll take it. Right, D&O insurance by itself, the existence of it isn't going to prevent board members from being sued personally. And actually that's what triggers coverage under a D&O policy, is if you get sued personally. I don't know if this question was really intended to ask whether board members could still be held liable personally, or if you could be forced to pay out of pocket. It depends on what the damages are. If the damages exceed what the D&O policy limits are, then that's a possibility. Limits are usually high enough to cover any damages. And Mike would probably know better about that. But so that's my answer to the first question. The D&O insurance is there in case you're sued personally. Also, the second question that was posted in conjunction with that, asking about or maybe I'm jumping ahead. Diane, I think I'm reading the question. I'm not sure you actually read this one, but I saw that the same poster asked about board members and volunteers and what their responsibilities are besides doing their due diligence and trusting experts. Honestly, I think I'd let Erin jump in on this one too. I think that is that's satisfying your duty. If you are consulting with experts in the field and you're exercising your due diligence about the contractors you speak with, the experts you speak with, there's not a whole lot else a lay person can do. Erin, what is your thought on that?
Yeah, so I just want to go back a second because there's obviously a big legal difference between negligence and reckless. And so I think what Mike and you were talking about is that D&O policy is going to cover your general negligence. So if you're a board member and you have a duty, and as everyone here should know, right? You have duties, you have fiduciary duties to your owners. And if there's a breach of that duty, if there's an alleged breach of that duty, but it only follows under negligence, then that D&O policy is going to cover you. But if you are found to have been act with wanton disregard, where it's going to rise to the level of reckless, that D&O policy is not going to protect you. And that is, frankly, the concern that should be the concern of some of those past and present board members for the Champlain Towers, right? If it's determined judicially that they didn't just have information and fail to act, but they had information and they chose not to act. They had all this information and they are found legally to have acted recklessly, to have endangered lives that could in fact expose their personal assets. So I think the shockwaves that went out after the Champlain Towers, people who are working on boards, such as yourselves, or volunteering on boards, right? Their initial concern is, wait a minute, if I'm serving on a board and I vote, let's say I'm the one who's voting to say, yes, let's get this work done, but I'm overruled all the time, right? Either by other board members or by the membership. Am I somehow still going to be liable if there is some injury or damage? Certainly we hope nothing to the extent of what happened on Surfside, but it could be a slip and fall. It could be, something relatively minor. But the short answer is that it's possible. You just have to be sure that you're not acting recklessly. And I know that's easier said than done. But I want to give a pretty concise answer to the question, which Barbara, you were right. I think the person is concerned that they could have their personal assets could be exposed. And the short answer is it's possible. It's unlikely, but it certainly is possible.
Well, thank you guys for seeing that. I appreciate you jumping in there. Chuck, what are the statutory requirements for condos regarding required structural engineering reports, and is there a Volusia County requirement?
To the best of my knowledge, there is no requirement.
Well, that was a short answer. So
yeah.
There you go. And there you go. Okay. Yeah. Another question that came in, I don't know if, again, Mike or the ladies. So an insurance appraisal, or maybe even Chuck, so an insurance appraisal should be used in conjunction with the reserve analysis, ? They should complement each other, not contradict each other, ?
Did we lose Mike?
Question again.
Okay, so that it's like, so an insurance appraisal should be used in conjunction with a reserve analysis, ? Or should they complement each other? Should they complement each other or not contradict each other?
They're completely separate.
Yeah.
So the insurance appraisal is strictly a function of the square footage, the type of construction, and we'll say the location. So that's really what, and the quality, not deterioration quality, but the quality of the type of building. So The reserve study is completely different. So they don't mix and match. But my point of saying that an appraisal firm that does a reserve study could be helpful is that they at least know the property. They know the manager, they know the people, they've got some idea and some relationship built there. So, but otherwise they're cousins and not even by the same, you know, family. So they're completely separate.
Thank you for that, Mike. Okay. I have not received any more questions that I am seeing. If you just have a question and want to unmute yourself and let us know who the question is directed towards in pertaining to this conversation, feel free to go ahead.
While we wait to see if anybody takes advantage of that, let me just throw in something else so that board members don't feel like, for instance, let's suppose someone here tonight has an association and you are struggling to get a special assessment passed, whether it's a significant project or you know, somewhat lesser. I have seen in some instances, and it seems extreme, but in light of certainly what happened in South Florida, it really isn't, right? If you're a board, you've been trying, let's say you're armed with information, an engineering report that says that there's a life safety issue, and yet you cannot get your members a membership vote to approve that special assessment, that's frankly where your attorney comes in, right? What is an alternative is to then put this in front of a local judge and say, Judge, we're asking you to order this special assessment. Here are all the reasons. Here's the information that we have. We cannot get this approved, and Judge, we're coming to you. And I have seen examples where certainly that has been ordered, and then it kind of takes the board out of it a little bit, right? It puts it into the judicial system. It puts it in front of a local judge, and the judge can obviously approve or deny that request. But it really shows that a board who's very concerned, who wants to be sure that they, you know, don't have the heavy-handed liability come down on them, that they have done everything that they can. And so I think that that's an option to be considered if you have to.
I have a question. Can you hear me?
Yes, sir. Go right ahead.
I would like you to, the lawyers, to elaborate a little bit more on recklessness and negligence. She talked about, you know, what you can do, but give some more anecdotal information on it, using examples or any lawsuits that you have seen that favored the plaintiff's attorneys.
So I don't know that I can come up with offhand. I mean, the general concept is you have a common law duty. I'm sorry, common law negligence, right? You have a duty. That duty was breached, and as a result of that, there's damages. Damages can be damages to personal property or injury. So reckless is the legal standard that's above that requires the element of intent, which means you act through your action or inaction. What resulted was a high probability of injury or damage or loss. And so that's that wanton disregard. I know I'm throwing out legal terms, but that
I would just add there's kind of an element of you knew what could happen and you just didn't care. You know, you knew the possibilities and you failed to act, as opposed to maybe not appreciating the circumstances and failing to act.
Yeah, and under the legal standard, the concept of intent is really key. So somebody can have a duty and they make a mistake. I made a mistake, and as a result of that, there was some damage. And maybe I made a mistake because I didn't have all the information. You know, those things happen all the time. And in those instances, if you, in good faith, as a board member, vote a certain way or something isn't done, again, it's action or inaction, you're not going to be held liable for that. Mistakes happen all the time. But the recklessness is, again, that element of intent. You intentionally chose to do something or not do something, and you were armed with information that you should have known that there was a high probability of injury or damage, and you still went ahead and did it anyway. Mm-hmm. It's a rare scenario, right? But that's what you need to look out for triggering personal liability.
Mm-hmm. And in the follow-up to that, in this instance, in this one down in Southern Florida that happened, what if the board all agreed that we have to do this special assessment? Would they be negligent if the association, the owners voted against it and did not want to participate in that, so they didn't take it to court? Are they then negligent? I mean, it's kind of a fine line there, because they're doing what they think. I mean, we always felt on our board that if it's something that had to be done, and it would be at the detriment of the owners, that we go ahead and do it anyway.
That's a really hard question to answer, because the difference between negligence and recklessness is a legal determination that's got to be made after looking at all of the facts and circumstances. And so as I sit here, I mean, there's just no way for me to say that. It's really going to come down to a lot of different factors, right? If it's ever really uncovered all of the information that the board had, and keep in mind that this was a board that had a lot of turnover. I mean, I think within the 4 or 5 months before the building collapsed, my information that I'm finding on the internet, so this is not, something that you can't, I believe something like 5 of the 7 members resigned. So this was a highly contentious issue dating many years. It resulted in a lot of infighting, a lot of people resigning and throwing up their hands and saying, I do this. So back to your question, it's very fact specific, the difference between the negligence and the recklessness.
Yeah. Okay, thank you.
Yeah, it's debatable like intent is. I said it's debatable like intent is.
Absolutely. Of course. Absolutely.
Yeah, right.
Good question. Thank you so much. Do we have any other questions from the floor that you want to ask before I ask the presenters to just make some tips that they could possibly offer just to help you as board members to just be, better board members in your role? Anybody else? Okay, Mike, do you want to jump in and just give a few tips for the topic at hand?
Sure. Well, when I look at insurance, I think I would just ask board members to, if they go out for bid, that they look at who the provider is, who the broker is, look at their experience, ask about beyond insurance questions, such as catastrophic planning, because that's another one that I think a board could get caught on their heels with, which I mean this, we're sitting here now, beautiful time of the year, it's hot, but a storm comes and let's say it does some significant damage to an association, and the board hasn't prepared with any catastrophic planning measures, like finding out who they could have on site to deliver services, who could commit to that. Just you kind of want to be thinking on those levels. That's not negligent, but it's almost kind of it's a fiduciary duty in my mind that a board be thinking about after the event, because we want to, the disaster is going to come, let's say, but let's not have a disaster after the disaster by then trying to find people that can help us. We want to create those relationships with people up front before it happens. So insurance, in terms of when I look at Champlain Towers, I'll just say this, that 1/3 of the building came down and 2/3 had to come down. So with insurance, it's called ordinance or law. So if you have I'll call it a typical, fairly typical property policy, it's going to pay for the damage of that third. So let's say that building was $38 million, which is pretty close. They would have gotten a check for, rounded up to 10 million. But what about the other 20 million plus that was still there in that building that had to come down? So if you don't have in your policy what they call ordinance or law, full limits, then you're not going to be paid for that 20 million. Thankfully, I know the inside of this a little bit. They did have that. The policy is going to pay the full limits and pay them for that 2/3 building that had to come down. So that's my take on when I look at what happened there from an insurance perspective. And I just ask you to think about catastrophically planning for an event that you hope never happens, but if it does, you got the team in place to do that, and let your broker drive that as part of the quarterback on a team event. That's everything I've got.
Thank you, Mike. I appreciate that. Chuck Adams, would you like to give us some just last minute tips as we wrap up?
Yeah, I would just say in summary, don't wait. Everybody on the board or the management should keep their eyes open. Look at what the building is telling you. If you see anything that looks wrong, spend a few dollars and have an engineer come out and look at it. You don't have to do a full damage survey, but have somebody who knows what they're doing come and have a look at it and tell you if you need to fix it right now or if you can put it off or whatever the next step should be. And then every 4 to 5 years, get a full damage assessment from a structural engineer and you'll be good.
Thank you so much, Chuck. Barbara and Erin?
Yeah, I think one of the things that I think is interesting from a nerdy lawyer perspective is that, there are thus far 5 lawsuits that have been filed against the association, and there will be many more. But to the information that I have, there's about 5, and every single one of them, right out of the gate, their first discovery request has been copies of the meeting minutes of the board meetings that have taken place from 2017 forward, and a real emphasis on what did the board do with the information that was presented to them. And in this case, it was from a 2018 very thorough engineering report that was really straightforward about the then condition of the building and the recommendations that were made. So I take that as a real warning signal, right, for everybody who's on here tonight, that what happens at your board meetings specifically in response to life safety issues and the condition of your building is critically important. It's critically important, obviously, that the conversations that take place at your board meetings regarding those issues, but how they are memorialized. I just think that the real takeaway here is that we harp about this a lot in the classes that we take, that your secretary is a critically important person. Because if you have something that happens years down the road, everybody wants to go back to those meeting minutes and find out, who voted what particular way, and what the discussions were and what the votes were, and was the board making a decision solely on the dollar amount, and that can't be always the most important factor in the decision. Of course, it weighs in. But your obligation goes beyond the dollars and cents sometimes. And so, Barbara, I don't know if you have anything to tack on to that.
You talk about the meeting minutes and how critically important those are. As when this happened and as it's unfolded, I've just kind of thought what I would do if I'm a board member to fulfill my fiduciary duty to take care of the condo property. And I think it's important for board members to know what's been going on with their property, know a little bit about the history of the building, find out what you can about what's going on, especially if you're in an association with such high turnover and one person doesn't know what's going on. It's hard to have that institutional knowledge when there's so much turnover. So as a board member, I would just encourage all of you to really get to know your building and look through the records, see what's been done, what hasn't been done. You know, discuss with your fellow board members, what do we need? A damage survey of the type that Chuck's recommending tonight. That's a recommendation I have for you as board members.
Yeah, and I'm going to hop real quick on that. I often have board members, you know, they get on, they start their service, and they don't ask a lot of questions. If they're looking at a budget that has a reserve account, you know, for X number of dollars for something, there's a tendency to just assume, well, that came from somewhere, and so they just carry on, right? Maybe those numbers came from the original developer. Maybe they came from a reserve study that was done 10 years ago. It's really not applicable anymore or accurate anymore. So, you know, again, when you're serving on your board, you do have, you know, I believe a duty, frankly, to ask some hard questions and to dig in a little bit and make sure that the information that you're sort of maybe rubber stamping by voting sure, make sure, ask the questions. Where did this information come from? Are these numbers accurate? Are they updated? Do they currently reflect the status of our building as it stands right now? Because it's very possible that those are just numbers that have continued to plug and play every year and nobody questions it. So, your point.
Yeah.
Mr. Annon, anything to add?
No, I think the information was pretty timely, and I think the comments about knowing your building and knowing your membership are probably pretty critical. I think that it's really critical. If you're a board member, you need to have some familiarity with what's happening in the building, and you certainly need to have some pretty good familiarity with what's happening with your membership. I think it's great information. I don't have anything else to add. No, thank you.
Okay, everyone, unless we don't have any more questions, we're going to end 15 minutes early. If you pop into the chat and send in a last minute question that came up, please feel free. We always take our videos, our webinars, and we post them on our website, which is ssmgfl.com. And I will go ahead and put that in the text to everyone so that you can cut and paste it and forward it to the rest of your board members who may not have been able to join us tonight. But we have a news and an education tab there, and we are regularly working on different hot topics for board members. So if you have any suggestions on topics that you want to learn about, also, please contact us so that we can either get a webinar set up or get you the information that you need. For our presenters, thank you all so much for taking time out of your professional days to help support the board members in our community. And with that, I haven't seen any other questions. So thank you all so much for attending.
Thank you.
Good night.
Thank you. Good night, everyone.
Thank you all.
Yeah.
Thank you.
Thanks a lot. Bye-bye.
Bye-bye.